If one of your colleagues has made awkward, uncomfortable, or even disrespectful comments about your pregnancy in the workplace, you may be wondering whether or not this conduct is permitted and what options you might have in this situation. I'm Mike from Cash and Legal, and in this video, I will cover the topic of inappropriate comments regarding pregnancy in the workplace. More specifically, I'll talk about what type of comments are permitted in the workplace and what type of comments are not permitted in the workplace. At the end of this video, you'll have a better understanding about what type of comments about your pregnancy are offside and what you can do if you've been subjected to inappropriate comments. To understand which comments about your pregnancy are permitted and which comments are not, it's important to be aware of the prohibition on discrimination in Alberta workplaces. Alberta's human rights legislation specifically prohibits discrimination on the basis of a variety of different protected grounds, including pregnancy. Discrimination occurs whenever an employee can prove three things. One, that they have a protected characteristic. Two, that they were subjected to adverse treatment. And three, that there was a connection between that protected characteristic and the adverse treatment. Now, there is one thing we should note about that analysis, specifically that a finding of adverse treatment must be assessed on an objective basis. This means the existence of adverse treatment is not determined with reference to someone's subjective experience, but whether the objective, reasonable person would consider that treatment to constitute an adverse treatment. Now that we've established the basics of discrimination, let's talk about what protections exist for pregnant employees under Alberta's human rights laws. Under Alberta's Human Rights Act, employers are prohibited from discriminating on the basis of gender, which includes pregnancy. There are some obvious things that employers cannot do on the basis of these protections. Employers cannot refuse to hire someone on the basis of pregnancy. They cannot reduce someone's pay on the basis of pregnancy, and they cannot terminate employment on the basis of pregnancy. These are some of the more obvious examples of the adverse treatment that is prohibited by Alberta's Human Rights Act. But what about inappropriate comments in the workplace? Things are a little less clear in this situation. Comments about pregnancy, including stereotypes about pregnant women, can qualify as adverse treatment under Alberta's Human Rights Act. There are some obvious examples of comments that would constitute discrimination, including suggesting that pregnant women can't do their job as well as other employees, or suggesting that a woman shouldn't be working because she is pregnant. Really, any comment about a pregnant employee's ability to contribute to the workplace would likely constitute adverse treatment under the Alberta Human Rights Act. But are there comments about pregnancy that would not be considered discriminatory? While the examples I just cited would likely constitute discrimination, there are comments about pregnancy that might not be considered an adverse treatment. As I explained earlier, for a statement to be considered adverse treatment under the Alberta Human Rights Act, it must have an objective seriousness in its overall context. Some human rights tribunals have explained that the level of comment required must be objectively offensive such that the reasonable person would consider it to have demeaned the complainant. This means that not every awkward or poorly worded comment will constitute discrimination. It must reach that objective level of offensiveness. To conduct this objective analysis, tribunals will look at various factors, including the frequency of the comment, the context of the comments, and the severity of the comments themselves. This means that a single offhand comment about someone's pregnancy, particularly if it's not tied to an individual's employment status, might not constitute discrimination. Another important consideration is who made the comments. If the comment is made by your manager or someone else in a position of responsibility, this increases the likelihood that it will be found to be discriminatory. Conversely, if the comment is made by a colleague who is at the same level and has no relationship to management, and the comments are never brought to the employer's attention, it will be difficult to establish discriminatory conduct by the employer in this context. Another example of a comment that might not be found to be discriminatory is any comment that was directed towards a legitimate attempt to accommodate a pregnant employee. Under Alberta human rights law, employers have a legal obligation to accommodate pregnant employees. Sometimes these accommodation attempts might result in awkward conversations. If a comment is made in this context, a tribunal may not find that the comment was discriminatory. I want to stress that I'm not trying to justify inappropriate comments in the workplace or suggest that this is appropriate behavior. My only goal is to emphasize that not every comment about your pregnancy is likely going to amount to the level of discrimination. Further, I do want to point out that tribunals will consider historical or ongoing societal marginalization when assessing whether a comment is discriminatory or not. So that means they will look at whether a comment reinforces negative stereotypes to determine whether or not a comment is discriminatory. So what should you do if you've been subjected to inappropriate comments about your pregnancy in the workplace? Firstly, it is never too early to seek legal advice in this situation. Our employment lawyers can assist you by assessing your circumstances and providing clear guidance on next steps. Apart from engaging legal counsel, if you have been subjected to inappropriate comments regarding your pregnancy in the workplace, the first thing you should do is report these comments to someone in a position of authority. If your employer has an established mechanism for dealing with this type of conduct, you should avail yourself of this opportunity. However, I recognize you may be in a working environment where you do not even feel safe to take this first step, or your employer has not even made this option available to you. In this situation, you may need to skip this step and engage a lawyer right away. If you're unable to resolve the situation directly with your employer, you have two options for legal action in Alberta: a human rights complaint and a constructive dismissal claim. What does the human rights complaint process look like? This process is specifically designed to remedy individuals who've been subjected to discrimination. The major benefit of the human rights complaint process is that you do not need to resign or be fired in order to pursue a complaint. In fact, in some circumstances, we find that filing the complaint alone creates sufficient leverage with the employer to facilitate a favorable outcome. If after filing the complaint, you and your employer are still unable to achieve an acceptable solution, there are different remedies available to you through this process, including monetary awards and even orders directing the employer to change their practices. That's the human rights complaint process, and you're probably wondering what the constructive dismissal process looks like. Constructive dismissal is a much more drastic and risky remedy and should only be pursued with the benefit of legal advice. Constructive dismissal refers to any situation where an employer commits a reputatory breach of an employment contract, such that the employee is permitted to resign and pursue a claim against their employer for severance. This can occur if you've been subjected to inappropriate comments in the workplace about your pregnancy and your employer has not taken sufficient steps to remedy the situation. At law, employers owe their employees a variety of different implied contractual obligations, and failure to address the situation where an employee has been subjected to inappropriate comments regarding their pregnancy may constitute a breach of those implied contractual obligations. This breach could give rise to a claim for constructive dismissal. However, constructive dismissal is a very serious option because in order to pursue a constructive dismissal claim, you must resign from your employment. For that reason, we only recommend pursuing this option with the benefit of legal advice. The bottom line is that pregnancy is a protected ground of discrimination, and inappropriate comments regarding your pregnancy might constitute a breach of human rights legislation and the implied terms of your employment contract. While not all comments about your pregnancy are actionable, an objectively offensive statement about your pregnancy could give rise to the remedies we discussed in this video. If you've been subjected to inappropriate comments about your pregnancy in the workplace, we can assist you with this. Our team supports pregnant employees by providing them with clarity about their circumstances, strategies for responding, and peace of mind through sound advice and strong representation. If you find yourself in this situation, you're looking for assistance, do not hesitate to click the link to our website in the description of this video and book a consultation with our office today.